morning, everybody. Nice of you to come on this lovely, warm summer day. I'm delighted to have you here. I used to teach here. Probably many of you don't know that, but for 28 years I was a professor at Ryerson. And now I'm what they call a professor emeritus, which means I'm gone. But today I'm going to talk about amending a declaration. So I'm going to talk about two things. I'm going to talk about the procedure for amending declarations, and I'm going to talk about some of the amendments that we've made to declarations over the years so that, you may go back to your condominium corporation and say, you know what, maybe we should look at this and see whether the declaration can be amended to achieve this. So I'll give you some ideas of some of the things we've done. So if you're going to amend a declaration, before you spend any money at all, in my view, you should do a survey of unit owners to see if there's any interest in what it is the board is contemplating amending. There's no point, in my view, spending any money on lawyers or anybody else unless you have a sense that you're going to be able to achieve the amendment that the board is hoping to do. So we always recommend a survey first off, unless we really, really know that it's a winner and there's going to be no problems. And we always recommend that the board hold an information meeting with the owners to see what kind of pushback they might encounter with this amendment. It gives the board an early start on understanding what concerns and questions and objections might arise from the unit owners in the condominium corporation if they intend to proceed with an amendment. Oh, I'm doing so well here. So here's what typically happens. The board does the survey, holds the meeting, gets an indication that people want to go ahead, and the next thing they do is really decide how they're going to go about the amendment. But I'm going to take a step before that and say legal counsel prepares the amendment to the declaration. And it may be a single amendment, it may be a whole series of amendments, whatever it is, it's done in writing, and the board passes a resolution approving the amendment or amendments to the declaration at a board meeting, and it's minuted, and the resolution is part of the minutes of the AGM. So, depending on what kind of an amendment the condominium corporation is contemplating, you may also require a surveyor to do new sheets of the description being the plans of the condominium showing the units, the common elements, and the exclusive use common elements. So if you're changing unit boundaries and or you're changing exclusive use common elements, you'll need a surveyor to match the changes that you write into the declaration with the sheets of the description that reflect pictorially what the declaration says. So when the declaration says the unit boundary is the outside frame of the window, the description has to show the same thing. So those two have to be consistent. So one of the things we'll do when somebody calls us and says, we're trying to find out who's responsible for what, is sometimes we can't just look at the declaration. It's not clear enough. The wording isn't easy enough for us. So we pull up the sheets of the description and we check what the boundary is in the plans relative to what's written. And those two should match. And we've had instances where they haven't matched, and we've acted for a surveyor to amend the description and so that they do in fact match where they weren't before. So the first thing you want to get is the quote from the solicitor, which should be way cheaper than the quote from the surveyor. So the surveyor's quote is going to be way more expensive. So before you, no, I'm still where I was. Yeah, it's your fault. So you're going to want a quote from the surveyor because they're shockingly expensive. Typically, an amendment to a declaration done by a solicitor should not be that expensive. It should be, it depends what you're doing, but, some of them can be done, not including the registration and stuff, but just preparing the amendment, well below $1,000. Anybody charging you more is charging you too much. So that's all of these things, by the way, you should know for your meeting with your unit owners. I mean, every unit owner is always concerned about costs. So you should be able to tell the unit owners, we've got a quote from the surveyor, we've got a quote from the lawyer, and it's going to cost this. The more answers a board has, the happier unit owners are that the board has done its homework. The meeting of owners, the corporation, so now you've had your information meeting, you've done your survey, you've decided to go ahead, you've prepared your amendment, whatever it may be, and the corporation is required to send a preliminary notice of meeting to owners, just like it does now. Interestingly enough, the amendment to the declaration doesn't have to be included in it, but I kind of think it's a good idea, and I'll tell you why. It gives people more time to think about it, and gives the board time to answer any questions that it needs to. So after you've done the preliminary notice of meeting, you send your notice of meeting just like you would for any other meeting of owners under the Condominium Act, and the notice of meeting must include the copy of the proposed amendment. Okay? So this is different than any other kind of meeting. This meeting is only called for the purposes of discussing the amendment. There is no vote taken at this meeting. So, in addition to notifying the unit owners, the board is also required to notify the mortgagees on record. And no registration, if the amendment is successful, can occur before 30 days after the notice has been sent to both to the mortgagee and to the owner. So you have to wait a period of time for people to object. So, approving the amendment to the declaration. The amendment to the declaration, as I said, is not voted on, period. You must amend a declaration in one of two ways. If you're doing it with consent of owners, you either need 80% consent of all of the units or 90% consent of all of the units. So an owner who is 30 days in arrears, more than 30 days in arrears of common expenses, is not entitled to consent, but you still need 80% and 90%. So it's not like the Condominium Act says, well, if there's 10 owners who have no right to consent, the 80 and 90% is of the number, not including the 10 who are in arrears. You still need to achieve your 80 or 90%. So the fact that they can't consent doesn't really help you at the end of the day. If anything, it may harm you. In the early years of a condominium corporation, if a board wants to amend its declaration, the developer has to consent if the developer hasn't transferred all of the units that he or she owns, and it's the later of 3 years since the condominium corporation was registered or the first agreement of purchase and sale was entered into. So you need both of those things to require the consent of the declarant if you want to make an amendment in the very early time of your condominium corporations. So, if you want to do an amendment by consent, you need 90% consent of all of the owners of all of the units. So if you have 100 units, you need 90 of them to sign a written consent when you're doing the following: changing the percentage of contributions of common expenses, changing the percentage interest in the common elements in Schedule D of the declaration. So I don't know how many of you are familiar with this because most developers are too lazy, but let me just explain how this works. I shouldn't say most developers, maybe they're lawyers. I take that back. The percentages of contributions to common expenses, everybody understands. That's the basis on which you calculate how much each unit will pay annually and then monthly. But what most people don't realize is that there are in some condominium corporations a different list, which is the percentage of ownership in the common elements. And that should be different, but it typically is not. So for example, if I buy a 2-bedroom unit on the 3rd floor, and I buy a 2-bedroom unit in the penthouse, there is a significant market value difference, okay? And that's what that percentage of common interest is supposed to reflect. So that if there is damage to the building, the guy in the penthouse will get more because he was in the penthouse than the person on the 3rd floor looking into the, the Gardner Expressway. But the developers don't create those charts, and their lawyers don't create those, and they should, because that is a reflection of what those people will get in certain circumstances. So usually it's identical, because it's the easy way to do it. You just allocate one percentage and you don't worry about it. The developer doesn't care what happens down the road, typically, and nobody's addressed it with them. They don't want to be bothered. So if you're changing either of those percentages, you need 90% consent. If you're changing the exclusive use common elements, you need 90% consent. And if you're changing the allocation of maintenance and repair obligations, you need 90% consent. Okay? For everything else, 80%. So there are only 4 things for which you need 90% consent. Now, the written consent must be obtained from the owners of units as of the date that the board passed the resolution. So if units have transferred ownership between the time the board passed the resolution and you're going to register the amendment to the declaration, the theory is you need those people who owned at the date of the resolution being passed, not the new buyers. I don't think anybody honors that at all. I just don't think anybody even recognizes it, and anybody cares. And in a big building, you'd never be able to do it really by consent anyway. So in a smaller building, it's easier, but in a big building, it would be very challenging, and I'm not sure that most people even care. So what we do is we like the consent to go out with the notice of meeting. There's nothing that says that the consent can't be secured when the unit owner comes to the meeting or whatever. There are some people who take the view that you can't get consent before the meeting, but we don't agree with that. And we do send it out, and we ask people if they will sign the consent. Now, we've used GetQuorum a few times, and they follow up with unit owners to make sure that the consents come in. But remember, it's really, really important to have the ability to communicate electronically with your unit owners. Because if you don't have the right to communicate by email, it makes collecting those consents so much more difficult. It means you got to go door to door, or you got to do mailings, or you got to put, something under unit owners' doors. So, and then dealing with non-resident owners, the whole thing is quite complicated. So it's important to make sure that you have the right to communicate electronically. And if you already have the right to communicate electronically with unit owners from before the amendments to the Condominium Act were made, there is a tiny little form that we use that just adds the extra wording that the Act requires, saying, I forget what it is, but some little expression that the Act requires be included. And we send that out, and we say, if we don't hear from you, we assume we can continue to communicate with you electronically. So it is very important to have those consents. Okay. Most of the time, we do it by an application to court under Section 109. So the consents with the amendments with consent are done under Section 107, and the amendment by court application is done under Section 109. Now, the application to the court is limited to a correction for an error or inconsistency. So what constitutes an error or inconsistency? I'm going to talk about some of the amendments to declarations that we have done. So we all believed for years that an error or inconsistency had to be an originating error or inconsistency, that it actually had to be a mistake made by the developer at the time of registration. And if it wasn't a mistake made by the developer at the time of registration, or it wasn't inconsistent, then you couldn't amend the declaration by court application. So, many years ago, we represented a condominium corporation very close to here that had a superintendent's suite that was part of the common elements. That was a very, very common way of creating super suites in the earlier days of condominium corporations, before developers created them as units and sold them to condominium corporations. In the old days, they were part of the condominium corporation, and you got that as a buyer of a unit. You got you would get a super suite. So that was the common way that it was done. But it wasn't created as a unit. It was part of the common elements of the condominium corporation. So this condominium corporation hadn't had a super for years and had been renting out the apartment, and now wanted to upgrade the apartment and sell it and put the money in its reserve. So this was like 20 some years after the condo corp was registered. So they came to us, they were clients, and they said, what do you think? And we said, well, you know what, we'll try a court application and see how it goes. We had a meeting of owners, and we had an objector. And when we did, we tried to answer all his questions. He didn't care. And when we did the court application, lo and behold, he was there. And what was really interesting was the court said, for the first time, I think it had to address the issue, the court said, the error or inconsistency can be today. It can be inconsistent with the operation of the condominium corporation today. It doesn't have to be an error or inconsistency that originated with the developer. And so what they said is, if you're not using the super suite for a superintendent, and you want to create it as a unit and sell it, that's inconsistent with the way the condominium corporation is operating today, and we're going to grant you the amendment, even over an objection. So we created this, we carved out the common elements that was the super suite. The surveyor created it as a unit, modified the schedule of common expenses that were going to be payable, because now we were going to get common expenses paid by that suite, and we sold the unit, and the condominium corporation put the money into its reserve fund, and now, as it has for years, only has a daily superintendent. They don't have a live-in super anymore. So there are these kinds of things that can be done, and that decision certainly helps in that it talks about the fact that the inconsistency doesn't have to be an originating inconsistency coming from the developer. If it's inconsistent with the way people operate today, that's great, and they will allow it. So in another case, the owners brought an application to put into place the way they had operated for 34 years. I can't remember what it was, if it was Windows or whatever, but they had operated incorrectly in accordance with their declaration. For 34 years, everybody had done it this way instead of what the declaration said. And the court said, you've operated this way for 34 years. It's inconsistent with the way the condominium corporation operates. We'll grant the amendment. So there are things that can be done by amendment to the declaration that people don't really stop and think about quite often. So let me just tell you some of the ones I've done. One of the ones I did by consent was to make a senior's residence completely non-smoking. So we did that. Absolutely unnecessary. We said a rule will work. They said we don't care. We want it in the declaration. Understand that if you put a restriction in the declaration, nobody will question its reasonableness in court. A bylaw has to be reasonable. A rule has to be reasonable, but the declaration doesn't have to be reasonable. So that was one of the amendments we did by consent. So one of the things I don't really learn about are condominium corporations who've made amendments by consent. Typically, I only get the court cases, so I typically only know about the ones that were done by court application. So one of the other things that commonly happens is where surveyors or developers screw up in something in their registered documents, they will often go back and ask the court to correct them. And if the developer is part of the application and the condo court doesn't object, the court will grant it pretty much automatically. In fact, most of the judges don't know anything about this stuff, so it's pretty easy to get it. It's amazing how complicated this stuff is and how little. I don't even think they teach condominium law in the law schools, and yet over 50% of our housing market is condominium now in Ontario. So one of the ones we did recently, smile Louis, was we changed the unit boundaries of a condominium corporation to include the windows and convert them from common elements to part of the unit. Done for a couple of reasons. One is different people in the condominium corporation had different interests with respect to the windows. Some didn't want to change them at all. Some wanted to retrofit them, and some wanted all new windows. And the only way that we could do that was to create the windows as part of the units. So we got 80% consent, written consent. The surveyor changed the description. We've changed the declaration, and we're just in the process of completing that. It becomes a lot more complex when people want to change windows in a condominium corporation, and you want to be sure that they do it right with the right people, etc. So it's become what looked like a simple solution has become incredibly complicated, like seriously complicated. One of the other ones that we did, one of the things you should know is that if you do try to get consent and you can't get it, okay, you just can't get it because practically it's just impossible. You can still apply to the court for an amendment. And the courts have said the fact that you tried to get consent, somebody objected and said they can't come to court because they weren't able to get consent, so they shouldn't have been able to come to court. And the court said, no, the condo can still come to court if it's an error in consistency, even though they were unable to get consent. So that's good to know. So here's one that's happened several times, always with the same builder. This is one where the developer, who shall remain nameless, has not allocated the correct common expense percentages to the unit. So what's happened is a small unit has ended up with way too high a percentage of contribution to common expenses relative to the other units in the building. In all the cases, the developer was told about it before registration. In all the cases, the developer didn't do anything. What's that? No, I don't think it's lawyers' fees. I just think, I don't know what it is. The lawyers' fees wouldn't be here or there. That change isn't significant. It's just a new Schedule D. It's nothing. Anyway, they wouldn't do it. There were, I think, a total of 6 lawsuits from 6 owners against this developer. So the most recent one was in a building that I represent, where the unit owner said to the condominium corporation, you go to court and you fix it. And we said, no, we're not doing that. It's not our obligation to fix a mistake by the developer. If the developer screwed up the common expense contributions, we still get our 100%. It's your problem, it's not our problem. So they went to court, and the developer objected. And the court said, absolutely, developer, you're totally wrong. The common expenses should be amended so that he's in the same line as everybody else, and he should be paying the same percentage interest in common expenses as everybody else in the line. And then the court-ordered costs against the developer. So all the costs incurred by the unit owner, who had to do all this and hire a lawyer and all of that was paid for by the developer. And we just sort of didn't do anything because we really have no interest as a condominium corporation in the allocation of percentages. So it worked out very well, but there are at least 6 units that have had that happen. So here's another one that's kind of interesting. We had a very high-end condominium client who, it was a very mixed-use building. And the developer, his lawyer, had written a clause essentially allowing the use of Airbnb in the building. The intention was that it should only be on one floor. But it didn't read that way. It's not how it came out when you actually read it. It looked like the whole building could be Airbnb'd. And we told the developer this before closing, and the developer said, not changing it. Don't want anybody looking to get out of their deal on the basis that I changed this provision. So after the registration of the condominium corporation, a few years after, not within the first period, as I mentioned earlier, so we didn't need the developer's consent. The condominium corporation applied to limit the Airbnb use to the one floor. And the developer supported the application by saying, yeah, they had screwed up and that was really their intention. And we had some objections, but we actually got it through. And so now only one floor is permitted Airbnb, and the rest of it just does it without permission. So, you know, as you all know. There was one application that we did lose that kind of really upset me, and that was for 2 condominium corporations who had a provision included in their declaration that allowed for Airbnb and short-term leasing up to, no, just short-term leasing, no limitation. And you couldn't do anything in the rules, you couldn't do anything to modify it. And it's a really, really residential building, these 2 buildings, and they really, really don't want Airbnb. So we tried to amend the declaration to remove the clause, and the court held we couldn't. It wasn't an error and it wasn't inconsistent. So we couldn't get rid of it. But typically, and of course there were objectors. Without objectors, we would have gotten it. Okay? Typically, without an objection, you would get it. And when you do this, when you do an amendment to the declaration, all the owners have to be served. So you would typically make a 2-fold application. You would ask the court to relieve the condominium corporation of using typical service through the court system, which means registered mail and this and that and the other, and you would just do it by communication. It depends how significant the amendment is. If the judge looks at it and says it's a no-brainer amendment, then you will get the right to do what we call supplementary service, which is a different way of serving that's much easier than the typical requirement of a court application, which is usually personal service. We're going to leave the questions till the end. Thank you. Anyway, then you want to register the condominium corporation. You want to register the amendment to the declaration and description. Your lawyer does this, but the condominium corporation has to swear a certificate under oath that the amendment was compliant with the requirements of the Act. And so you have to swear that proper notices were given to the owners and mortgagees. That's what you're essentially saying, that the meeting of owners was held and that you have obtained the appropriate consents from the appropriate people who were owners at the time the board passed the resolution. Now, the certificate doesn't say any of this, but that's theoretically what you're supposed to be saying. And the records, the consents become a record of the corporation. So, that's my talk. Now we open the floor to questions. Questions?
You said that changes to be approved by the court. What kind of court? Is it like
Superior Court.
Superior?
It's Superior Court, yeah.
Hi, Audrey. For those of us who manage buildings, in the corporation where you could not change the declaration with respect to Airbnb, what does the management company or the board do to try and control the Airbnb in the building? Is there anything, or it's just...
You just make sure there's no chairs anywhere near the balcony. I really, really resent developers who do that. But I have persuaded one developer to not permit short-term leasing in their buildings. They've agreed that it is not good for the environment of the condominium corporation, and they have limited their any of their leasing to the minimum is 30 days, which I still don't think is enough. But anyway.
I have a question. We are trying to repurpose a share facility unit, which is now a pool, a whirlpool, one of those small ones with waves. And it's actually located in a position very close to an electrical room. And we're in a situation where we have had a leak in the past. And I'm trying right now to repurpose. Would I have to go through the whole thing with amending?
No, you use Section 97 for that.
Perfect.
Yeah.
Thank you.
Under administrative law, what would constitute a minor irregularity and therefore a non-actionable legal action or application to the court? So they would say, yes, there's an inconsistency, but it's a minor irregularity and therefore dismissed. What would be the criteria from your knowledge, from the case law you've reviewed, obviously as a lawyer in real estate law, that would constitute circumstances, like a spelling error, a typo error, a clerical error, I mean, that type of thing?
We would recommend the board just leave it. We wouldn't recommend that anybody make an application under those circumstances. And one of the biggest problems we find is inconsistencies in the declarations. So we find that in different places, typically with unit boundaries and maintenance and repair, we find that the developers, lawyers, and surveyors haven't been necessarily told during the time of construction that a change has occurred. And nobody picks it up when they're reviewing the final set of documents. Or they're just sloppy. They've picked up, a paragraph from this document and a paragraph from that document, and they don't match. We usually give, in those circumstances, if it's really bad, we would apply to the court. But typically, we just give our opinion on how the condominium corporation should operate based on our experience, what would be the most likely interpretation of the clause. And, so for example, one of the things we often see is that the windows, the glass, will be the responsibility of the unit owner, but the frame is the responsibility of the condominium corporation. So we take the view that whoever has the preponderance of expense should be responsible for the entire expense. So we don't think that unit owners should be hit up for the glass and the condominium corporation should pay for the frames. So we often will apply a principle that says whoever pays the most with respect to that item should just pay the whole item. It's just easier. It lets the condominium corporation function properly. And then if the condominium corporation functions like that for years, you have the case law that says that an amendment to the declaration would be granted if applied for, so you don't even bother applying for it. We really try to keep it simple. And wherever we can help, that's just our practice, wherever we can help a condominium corporation operate without the need to spend a pile of money doing things that are not necessary, that's typically the approach we try to take. We found that our clients really appreciate it.
Thank you. Excellent. Are you familiar with TSCC 1556? Because the
Just
judge
talked about it.
Yeah, exactly. The judge made some very cautionary comments, including a recommendation that the recourse should be through legislation if the threshold is too high. And I thought it was very interesting. He says here, the remedy is not to take what is fundamentally an amendment to a declaration that the board desires and repackage it as an inconsistency in order to seek relief. In other words, the shortcut, he struck down the shortcut.
Yeah, but the point with that one is that the municipality prohibits Airbnb there. So it's inconsistent to have a provision in the declaration which is prohibited by the local zoning bylaw. And that was the argument that we made, that the declaration wasn't consistent with the zoning bylaw, and the judge just, the objections were too strenuous, and the judge, I don't think, got it. And I'm not sure that maybe our evidence on the zoning was as good as it should have been. I think there was a bit of a mix-up there, slip-up there. I apologize for that. But honestly, I thought that one was a winner. So just goes to show you. I'm usually very, very cautious, and my gut is usually really, really good. When I hear something, my gut tells me, yeah, that's good or that's not good. And on this one, I was just wrong. I thought we'd get that. I was extremely disappointed and embarrassed.
Just getting back to the short-term rental and Airbnb, our declaration was written in 1971. So to go back and change things is like ridiculous.
Yeah.
Would you suggest bylaws are sufficient to cover something?
No, a rule.
A rule?
You only need a rule.
Rule only.
The courts have upheld rules. It's absolutely fine.
Thank you
That's
so
the right
much.
way to go, and you don't need a vote of owners. You just give them notice, and then they can requisition a meeting.
Great, thank you so much.
One of my favorite stories is many, many years ago, I had a condominium client, a high-end condominium client that spent like $300,000. This was years ago, renovating its like meeting party room kind of place, where they had a bar, and it was lovely. And they decided they didn't want any smoking in it. So they passed a rule that said no smoking in the, I can't remember if it was in all of the common elements or just in this beautiful room. And I did the rule, and we sent it out. And they said, well, what if we get a requisition? And I said, don't be ridiculous. Who's going to requisition a rule like that? And then they sent me the requisition. And I said, oh my God, I can't believe it. Anyway, I went to this meeting, and it was unbelievable to listen to the people. There was one guy who actually stood up and said, smoking isn't harmful. There was another person who stood up and said, well, I don't want to smoke in my unit because I don't want it to smell, so I want to be able to come down here and smoke. Anyway, it was really interesting. The place was packed. And under the old act, the rule only became valid if the majority of owners at a meeting voted in favor of it. So we were quite nervous. As it turned out, we had enough proxies to cover it. But now, I don't know if you're aware of this, the new act says that a rule becomes effective unless it is voted down by a majority of owners. So it's nice to have the ability. So if a meeting is called and they don't get quorum, or a meeting is called and the vote doesn't vote down the rule is automatically in place. So it makes it much easier. We used to have people requisition meetings and not show up, and the rule was defeated. So we were able to persuade the government to make that amendment.
So in continuation with what you were just saying, my condo has just created a rule and sent it out. We are aware that a group of people are going knocking on the doors trying to get a requisition. So if they get the 15% and they come to the meeting, will the 15% who are voting to say no win?
Well, it depends how many people show up. So if you have proxies this is the kind of place where you want to use GetQuorum, to be perfectly honest, or because they can electronically, if you have the right consents, get enough votes in so that the 15% isn't enough to overturn it. So you need a quorum of 25% at the first meeting. So you want to have enough in your quorum that you can defeat that 15%.
So I should have sent a proxy form along with the package? Is that
No, because when you get the requisition in, then you will send out a package with a proxy form.
Okay, thank you so much.
All right.
Quick question. Could you put director qualifications through a rule, or does that have to be through bylaw?
Bylaw. Director qualifications has to be through a bylaw. And we're doing a lot of them now. So here's one of the things you may not know. You know the Condominium Act now requires developer disclosure. But that disclosure doesn't disqualify the individual from being on the board. So if you don't, just because they disclose that they're crooks or they're, and they don't have to disclose that they have a criminal record, they only have to disclose if they have a conviction under the Condo Act. Well, nobody's ever been convicted under the Condo Act. They brought one prosecution and they lost, and that was about 30 years ago. So, I mean, I'm sure now there will be more attempts at it, but the point I'm making is if you want to qualify your board members, you have to do a bylaw. And for the lady, particularly in the old condominium from 1971, if you don't have good bylaws and good rules, you're really, really in trouble because so much has changed since 71. I mean, it's unbelievable. Yeah.
To tag on to that, we're in an 18-year-old building. A lot has changed, like you say, and we've got a number of bylaws that we want to change, probably 6 or 8, standard unit, short-term rentals, all of the above. How do we best facilitate those changes?
The best thing to do is rewrite your bylaws, period.
Period?
Yeah,
Full
just
stop?
get a whole new bylaw, get rid of 6 or 7 bylaws, have one bylaw that people can look at, incorporate all the changes you want into the new bylaw and call it a day.
Okay.
And it's much cheaper than doing it piecemeal. If you try to do it piecemeal, you're going to pay a lot of money per bylaw.
Exactly.
If you just go with a whole new bylaw and make sure, you know, what you want is in the new bylaw, then that's much less expensive.
There's probably about 6 to 8
Yeah.
that we need
Well,
to
we
change,
usually do a
so
standard unit bylaw separately, but it doesn't have to be. It can be done as a schedule
it's
to the
just one of the
operating
changes.
bylaw.
Right.
Yeah.
Okay, thank you.
All right. Well, thank you very much, everyone. Audrey, thank you very much for your time. Minute Solutions, Switch, thank you very much. And hopefully we'll see you guys in a few months. Have a great day.